Many people feel the justice system is broken, and understandably so, because we've had many clients come to us with cases brought against them that are entirely ridiculous, and to resolve them, they had to go to significant expense in hiring lawyers to sort it all out. Because whether it's a small claim or a claim for £50,000, or even in one case brought against my own firm for over £2 million, which was entirely ridiculous and was struck out initially on the papers, still took 5 years and a lot of effort to get resolved. And the case was ultimately ridiculous. I'll tell you about that in a minute. Now, this video is really a bit of an overview of things you might look out for and how you might resolve these things as you go along, and hopefully even before they happen. You can listen to it as a podcast, you can save it for later, you can share it with somebody else. But essentially, I started this channel during the lockdown because we all had a bit more time on our hands, because at the outset, at least, the courts were shut down, all but the most serious cases, and we had more time on our hands. So I created this channel to help you understand law. I am so pleased and humbled now to have so many hundreds of thousands of subscribers here to continue to help you to understand law and to talk about news articles and so on. So this video is really an overview of what you might do if you end up in the situation, either where you need to bring a claim or you've had a claim brought against you, maybe to help prevent bringing these claims against you in the first place, and what you might do if that happens. So if you're new to me, I'm Daniel Shensmith, a barrister of England and Wales. Please do hit the subscribe button. That helps my channel grow. And this is probably going to be a slightly longer video and hopefully pick up the algorithms for podcasts and so on. So let's get into it. So first and foremost, what a lot of people do is ignore a problem. And even before they ignore a problem, if we back up even further, they create their own problems by not committing things to writing, not getting formal agreements, and not being sure of where they are in any contractual arrangement. This is really where it all starts, because despite the phrase, if it's not written down, it didn't happen, that is not entirely true. You can prove verbal contracts in court, but obviously that's more difficult than having a written contract that's been reduced to writing, and everything that you've agreed has been reduced to writing. And so that is much easier to refer back to when you get to court. But that is the biggest problem that people have. They don't commit these things to writing. And surprisingly, the biggest thing that we see is where someone has had work done on their house, or they've bought a second-hand car from a dealer and they haven't got proper paperwork for it. So, a proper invoice and all that sort of stuff. Those are somewhat easier, particularly if they're acting in their capacity as a consumer, because it is just a vehicle. But even still, they have significant problems with them as well. I've done a lengthy podcast on dealing with problems with cars. You'll find that on these podcast lists here. But one of the big problems people have is when they have work done on their house, they typically get one or two builders come round and quote for the work done on the house. And they go ahead. They might transfer £10,000, £15,000, or even sometimes the whole lot. And that could be, £30,000 or £40,000 We've seen up to maybe £100,000 worth of work being done on a house, only for a year later, it all to be unraveled that the work was shoddy workmanship, very poor quality, lots of things not done or things done badly. And they end up in the situation where they have this dispute with all the money they've paid. They're left with a house with shoddy work done to it, and they need it rectified. And as any builder will tell you, it's often more expensive to rectify bad work than it is to start afresh, because you somewhat have to undo what's been done already and then put it back where it started in order to do the work properly again. But believe it or not, so many people, and if you're listening to this now, you may realize, actually, yeah, I'm guilty of that. I've done that myself before, and I've done that before. Even before I was a barrister, I've done that before. So this is no criticism of people that do that. You do it out of trust and sometimes out of embarrassment, that you don't want to tell the other person to commit it to writing, because there's sort of a stigma attached to saying, let's get this down on paper, because some people think, well, they'll think I don't trust them, and I want them to think I trust them because I'm a nice person. So inherently, most people want other people to like them and to trust them, and They want to feel that they are trustworthy and that they all trust each other. And so ultimately, they don't get these things down on paper. Now, if you ask the builder to commit this to paper and write down exactly what's going to happen and by when, and are they providing the paint? Are they decorating things? And to what extent are they decorating things? Are they literally, these are some of the problems that we've heard of with our clients. Are they plumbing things in, when they fit a bathroom? Believe it or not, we've had a builder before now say that the plumber's bills are extra to the work that they're having done. Let's say they're having an extension which includes a bathroom, or let's say they're having a work done that includes a kitchen. Some of them have said that the plumbers and the electricians and everything else are extra. Now, they obviously can be thousands of pounds, but then they are thousands of pounds on top of what they've already agreed, and that can suddenly become very expensive. So you need to get these things down on paper. Now, what happens is if you speak to the builder and you say, let's make sure we get this down in a written contract as to exactly what you're going to do, by when, and what I'm paying for that, and by when am I paying for that. If the builder is either reluctant or worse, just flat out refuses to have it put down in writing, then I would suggest it's not the builder for you. Because if you've got a problem at that stage in agreeing, formalizing what you're agreeing at that stage, then what do you think it'll be like later down the road when there is a problem and they say, well, I didn't agree to do that. That wasn't part of the arrangement. That wasn't what we agreed. And then it's your word versus theirs. And the only way that is resolved, if it's not resolved between you, is potentially at mediation. A lot of cases do settle at mediation, but that is long and stressful and can still be expensive. And ultimately at court when you go to a decision. As the saying goes, at mediation, you may choose an outcome. At court, you get an outcome. And even at court, even if you get the outcome that is in your favor, you'll still feel like you lost. Most people that go to court, even if you technically win the case, even if you flat out win and you get the judgment and everything else, you can still feel like you've lost because you've spent all the time, effort, stress, and money up to that point. You then might get a judgment, and then if it's a huge judgment against a relatively small company, they will dissolve the company. They'll just not end up paying you, and you ultimately lose anyway. But all of that, winding that all the way back to the beginning, if you get these things down in writing, and if they are reluctant to do so, then you move on. That is my suggestion. You move on to a company that says, no problem at all. Let's put down exactly what we're agreeing so we all know. And any reputable company will do that at the outset. They will put down, it might come in the form of a quotation. That is not strictly a contract, but it is a written document upon which your contract will be based. And so if you agree to what's being quoted and you pay for it, then that can later be used in court to say this is what they offer to do for how much money, and we agreed to do it. So that is then usually fine. So let's skip forward and let's say that you've got to this stage now where there is a problem. Now, it's either a bona fide, genuine problem between you, or it's just a ridiculous one. Let's take an example of somebody trying to renegotiate the fees for work done after the event. Now, this is one such case we've had very recently, which is why it's fresh in my mind. You've got a case where someone has agreed to do a certain amount of work for a certain number of hours at a certain rate per hour. And then later on, they think, well, actually, that's not enough. I want more than that. So they demand more money, and they write to the company and say, I want more money. This is not enough. I'm not accepting what you've originally agreed. I want more money. Now, obviously, you can't do that. You can't come back and renegotiate terms once you've already agreed the contract. So understanding when you are in a contract and when the contract has been formed and what the terms of that contract are. Again, going back to what I said, if it's in writing, it is far simpler. But even for the simplest arrangements, I would say get them in writing. But let's say now you've got this person saying that they want more money than was originally agreed, and they are essentially threatening you in all sorts of different ways, one of which the only legitimate way is threatening to sue you, because they say that if you don't give me X, then, I'm going to sue you. You can't stop someone from threatening to sue you. but it can be considered aggressive behavior if they continuously threaten to sue you and don't follow through on it. There is case law on that as well. But if you get to this position where someone has threatened to sue you, what I suggest you do is you don't just ignore it and bury your head in the sand. There's two responses people to have to problems, and that is they either bury their head in the sand or they tackle it head on. There's a few in between, but broadly speaking, that's what people do. They either bury their head and ignore the problem completely. They ignore messages. I have situations at the moment where I've sent message after message after message and letters, and people just do not respond. If you don't respond, it gets worse. That's the only thing I can really promise you, is that if you ignore a problem, it will get worse. So what you do in those situations is you talk openly and frankly about the problem. Now, there's two types of communication. There's open and without prejudice. Without prejudice essentially means private and is a genuine attempt to resolve the issues between you. And the issues might just be money. They very often are. The issues might be you said you were going to do X and you haven't done X, or you said you were going to give me X and you haven't given me X, and that's an issue. That's not necessarily money. Whatever these issues are, I would encourage you at all times to continually try to resolve these issues between you, because court should be a last resort. If ultimately you end up in court, you need to be able to show, particularly when it comes to costs at the end, you need to be able to show that you've been reasonable. And that's where the without prejudice comes in. Now, any genuine attempt to settle these issues between you is going to be considered without prejudice, even if it's not marked without prejudice. And the court will not usually look at that correspondence if it is a genuine attempt. Now, if I give you this much and you do that could resolve things, you might say in letters. The court's not really going to give those letters much consideration if they are deemed to be without prejudice discussions and genuine attempts to settle. You might rely on certain things in there, but it depends on the context of the overall letter. For example, if there's blackmail in there, if there are threats in there, if there's any element of fraud in there, you might reference those in court. But if it's just a genuine attempt to settle, then you won't be referring to that in court. You'll be referring right back to the agreement, what was agreed, what were they supposed to do, and so on. Now, the reverse is true as well. If something is marked without prejudice and there are threats in there, then obviously you do refer to it in court, regardless of whether it's marked without prejudice or not. Without prejudice isn't a magic tag that means you can't reveal it to the court, whatever the circumstances. It just means you be careful. But as I said, you have this discussion with each other. You're supposed to have this discussion with each other, and parties are under a duty at all times to try to correspond with each other to resolve these issues before it goes to court. Now, then, if you get beyond that stage and you think you really can't resolve this amicably on a without prejudice basis, then we move to open letters and an open letter before action. So each claim, each type of claim, whether it's a civil claim, a defamation claim, and so on, they have their own, what we call a pre-action protocol. These are the steps that you follow so that the other side has a clear picture of the case that they're going to meet if you go to court. Now, you need to comply with this, particularly if it's a complex case and you file a claim without doing this, the court might ultimately stay, i.e. pause the case until you've complied with this pre-action protocol. The purpose of the pre-action protocol is to put each party in the situation with enough information, enough detail and the facts of the case they're going to meet so that they can properly meet the case when it's pleaded in court. And you should comply with that. And it also has an effect on costs at the very end as well. So then you get this letter before action. And so if you get a, let's just call it a ridiculous claim, let's call it what it is. Let's say you get a ridiculous claim to try to renegotiate terms after the event. Someone's offered to do work at a certain rate. You've paid them that rate. They come back saying, no, actually, I want more because I don't think it was fair. They then try to say that you've manipulated them or you've done some, this wrongdoing on your part to try to get them to agree in the first place. But there's nothing really that backs that up. Even if the claim is utterly ridiculous, then they would still need to send you a letter before action. You still need to deal with it. You still need to respond to it. And ultimately, you still need to respond to the claim that they are alleging against you. But in that situation where you have a completely baseless claim, and the way we refer to that in the rules is that there is no reasonable basis for the claimant to bring that claim in the first place. And in such an event, the court has the power to strike out a case. On both sides, as it happens. If we switch this around for a minute, if the defense is utterly ridiculous, let's say there's a contract to supply something, it's been supplied and it's just not paid for, and there is absolutely no suggestion that there's anything wrong with it, they just haven't paid, and let's say the defense is, I changed my mind, I just don't want to pay this amount for it, I only want to pay half for it. That has no basis in law. And so there is no real grounds to defend the claim. And so under the civil procedure rules, the court might strike out a statement of case, which is either the claim itself, the particulars of claim, or the defense, if the statement, the claim or the defense discloses no reasonable grounds for either bringing the claim in the first place, such as in our first example of trying to renegotiate the deal after the event, or defending the claim. In the example where they say, I changed my mind, I only want to pay half for it. So, for example, if, let's take, this probably wouldn't happen with cars, but let's say a car dealer delivered you the car and you said, well, actually, no, it doesn't quite fit in my garage, therefore I want to pay you half the amount for it. That probably wouldn't happen with cars because the car dealers are usually a bit more shrewd than that. But let's say it was a private contract, because contracts exist between individuals just as they do with companies, regardless whether some people believe that they don't exist between individuals if it's not written down. And, some people say, well, it wasn't written down, therefore there was no contract. That's not true. There can still be a contract between you. But let's say that they just say that and therefore they don't want to pay the same amount, etc. There'd be no reasonable grounds for defending it. So what you would do is, even before, if you think it's so ridiculous, if you get this claim, so now we've skipped forward, let's say they file this claim in court and the first thing you hear of it is now there is a claim form through the post for what you think is an utterly ridiculous claim. There is a procedure within the rules where you can apply to strike out the claim on the basis that it discloses no reasonable grounds for bringing the claim in the first place. So let's say the claim is for the difference in money that they think that they should have because they tried to renegotiate the deal after the event. If they then say, well, you agreed to pay me this much, but actually having thought about it after I've done the work and so on, I think it's worth this much. And then they try to claim, twice the money or 3 times the money from you after the event. That obviously has no basis in law. There's very narrow reasons that there might be. Let's say there was deception involved, but we're not talking about those at the moment. There's no deception. There's no other suggestion that there was anything wrong or nefarious about this arrangement. It's very straightforward. It was an agreed number of hours, an agreed rate. That rate was paid, and then they try to double their money to say, actually, I think it's worth more than that. The law won't protect you from a bad deal. So unless, as I say, there's some kind of nefarious acting on one part or another, or deception or whatever. But otherwise, the law won't protect you from a bad deal. So if you've taken that deal and you've agreed to do the work, you've done the work, and then you realize, actually, that's not good enough, and they bring a claim against you, then there is no reasonable ground for bringing that claim. So if in that situation, and it's very straightforward, you could apply to the court to strike out this claim even before filing a defense. And so while the court is then considering that application, the court might consider that on the papers. So let's take my example where my firm was sued for over £2 million. I'll go into the full story in another video, but it was utterly ridiculous. There was no basis in law whatsoever to support a claim for £2 million against the company. And so the application was to strike out the claim on a number of different reasons. There was all sorts of allegations within that claim, each of which were baseless, and the court ultimately did rule to strike out the claim. But as I say, these do take time. And if you don't know how to make these applications under the rules, then you may well struggle to do so. So, for example, here is the part of the civil procedure rules where the court has the power to strike out a statement of case. These rules are freely available. This is the Westlaw version, which is freely available, but also you can search for the civil procedure rules, and they're on gov.uk as well. And with these rules, it tells you what you can do and what powers the court has to strike out these claims in different scenarios. And so when you've made your application, and the forms are online for that as well, you can make this application to the court, and this is in this one here, which is an application to court. It's an application notice called an N244, and there's guidance notes with it as well. And you fill this out, you say who the parties are, what you're applying for, and why, and you support it with a witness statement. And there is also, there are guides to witness statements online as well. Perhaps I'll go to those in another video. If you like this sort of style of free-flowing thoughts to help you and assist you in this legal process, which is what I created this channel for, do pop your questions there, and I'll do dedicated streams and talks on exactly those as well to try and help you with those. We'll do one perhaps going on about a witness statement to support an application such as this. And so you make this application to the court. Then what happens is the court, albeit it takes its time, the quickest I get them back is usually a few weeks. The court might take a couple of months to come back, depending on how busy the court is. And then the court will either decide on the papers, which is one of the options that you can mark on the application. If you want the court to make a decision without a hearing, there's an option for that. Alternatively, now in the updated forms, there's an option for a remote hearing. So since lockdown, the courts have been doing lots more remotely. And so the court will hear these applications remotely. You'll jump on cloud video platforms, CVP. Some courts are still doing it with Zoom, I believe. And you attend remotely, and your room effectively becomes a courtroom, and you're under the same obligations and stringent controls as you would in a normal courtroom. You can't record it and so on. And then the court will make a decision, and you'll explain why. It's not a trial, but your witness statement of evidence as to this is what happened and this is why I think the court should strike out this claim. The court will consider that. And if the court, it's quite a draconian step, quite a harsh step for the court to take to strike out a statement of case. But if it is absolutely clear cut and you face one of these ridiculous claims against you, you will be doing the court a favor, i.e., in professional terms, you'll be furthering the court's overriding objective to deal with cases expeditiously and cost effectively by assisting the court to strike out a claim that should not go to trial. And so if a case is, as I say, to use a frank word, if it is a ridiculous claim against you, this is one step you can do to deal with that. Now, as I said at the very outset, many people feel that the system is broken because you have to jump through all of these hoops. But the only way that these ridiculous cases are distinguished from genuine cases is to go through this process. The court is not going to have a pre-read and decide by itself on a routine basis. The court can do that. The court can, of its own motion, strike out a claim. And I have seen situations where, to coin the phrase, the court has said, given the substance of the defense, are you sure you want to proceed to defend this claim? In other words, the court has hinted, this is not really a defense, so might you go back and consider settling it? All the while trying to limit the drain on court resources and court time where either the claim is ridiculous or the defense is ridiculous. And so if you can take steps in that direction to assist the court, it's what we will call a disposal. The court will try to dispose of the case and the issues within the case as efficiently as possible. So if you can make the court's life easy by doing so, then you stand a good chance of having your application successful. Now, as we often teach trainee barristers, new barristers, that if you make the court's life easier, then you are more likely to get your application through and your application successful. And ultimately, making the judge's life easier in every respect is always preferable. So the more you can do to assist the court and assist the judge, the more helpful you can be. And I've even had clients feel critical of me and other barristers for assisting the court in find a document that actually is exhibited by the other side. But that is not sort of working against the client. That is working to assist the court, because all the while, if you are helpful to the court will see you as being helpful and is more likely to rule with you, because you are more likely to be helpful in your own case and therefore more credible and so on. So all of these things do matter and they do add up. So if you get a frivolous case brought against you, that is one step you can take. So if that has been useful to you, please do hit that like button. I will try to keep these talks to roughly 20 to 30 minutes. And let me know what aspects of that you want to go into in any more detail. But these are just a broad overview of different thoughts that I have with cases that come to us, the stages we have to go through, and ultimately what people will end up paying for assistance in drafting these witness statements and these application documents to get these cases struck out, or defenses struck out, as the case might be. So if you found that useful, please do subscribe for more content. Do share this around, save it, come back, listen to it again later. And as always, thank you for watching, thank you for listening, and I will see you very soon.